All right. We got everyone here. Erickson, hello. I'd say nice to see you, but Okay, so I guess we'll just call this meeting to order. So my name's Matt Wilson. I'm the hearing officer. I have reviewed all the materials presented. I know. Say your last name again for me, Blake.
Hoffmeister.
Hoffmeister.
Yeah.
Well, you see your name.
Yeah.
Mm-hmm. So Mr. Hoffmeister has some additional materials that he's provided to me. So I'm not as fast as probably Tammy is, so I haven't been able to review all that now, but I will review that. But so I have reviewed the materials that were provided in the link. And I guess I will just turn time over.
Yeah.
Like, just keep in mind, you don't need to rehash all the materials. I have reviewed those and I can review the additional materials.
Okay. Yeah, again, was there a reason that updated materials weren't uploaded to the link?
So we were getting continuous uploads to Frontier. We have to kind of cut it off at some point. We can't keep adding stuff and sending it to the hearing officer days or weeks before, so we had cut it off when we had set the meeting date, that's why.
Which is fine.
Yeah.
Because I can still review it and it'll still be part of my decision. I probably won't issue a decision based on that today, but I'd like to hear any additional arguments that you have and then we'll hear from the county as well if they have any response.
And is there a time limit for this or?
I'm gonna leave that to the director and the hearing officer.
Typically in meetings, applicants have 3 minutes to explain the case.
Okay, and this might be a little bit more of a unique case, and yeah, I'll try to keep it as brief as possible. Okay, well, yeah, thanks for having me. For the record, my name is Blake Hoffmeister. I'm appearing today on behalf of the DH&MH Family Trust. The trust stands before you today as an adversely affected party under Utah law. We filed this administrative appeal to request you review a fundamental error committed by the planning division before we can get into the substantive failures and decisions from the substantive failures and deviations from the 2015 zoning development agreement. I think first it probably makes sense to just dismantle the jurisdictional shield that the staff has raised. The planning division has moved to dismiss this appeal. They're asking you to throw away the matter on a procedural distinction, recharacterizing the definitive written determinations issued by the principal code enforcement officer in February as mere informal email exchanges rather than a reviewable land use decision. Staff's position is that, and I don't want to put words in your mouth, I'd actually love to hear your opinion on it, but that because the principal code enforcement officer decided to communicate via email, no formal appealable land use decision ever occurred, despite me receiving an email entitled with the subject code enforcement determination from the principal code enforcement officer. Respectfully, this is irreconcilable with the plain language of LUDMA. I direct your attention to the statutory commands within LUDMA, section 1779-102. The legislature has explicitly codified the definition of a land use decision to mean an administrative decision of a land use authority regarding the enforcement of a land use regulation, land use permit, or development agreement. That's the definition of land use decision in LUDMA. Again, the enforcement of a land use regulation, land use permit, or development agreement is what LUDMA states, is the definition of a land use decision. So let's look just at the facts. When the principal code enforcement officer issued her final written statement, explicitly stating that Powder Mountain West is not part of the ZDA, that the ongoing restriction of public access is a civil issue, that the county does not have any say, and she was not giving casual advice. It was not water cooler talk, so to say. She was executing a final binding administrative interpretation by declining to enforce a recorded development agreement. By command, based on the code, a formal administrative refusal to enforce a recorded ZDA is an administrative land use decision, per the definition I stated earlier. Under Utah Code Section 1779-1003, any land use applicant or adversely affected party has an absolute statutory right to appeal an order, requirement, decision, or determination made by a land use authority in the administration or interpretation of land use ordinances. If this office does not assert subject matter jurisdiction today, it would mean that the county staff could completely insulate itself from any enforcement failures or successes from administrative oversight simply by typing it into an email. That is an untenable result that flips the legislative intent completely on its head, and this office has a clear jurisdiction to review the determination for correctness. Furthermore, the county jurisdictional defense suffers from a severe, fatal internal logical conflict that I'll term the privilege paradox. Staff cannot stand before you today and argue with a straight face that this code enforcement exchange was a casual, off-the-cuff, non-binding chat, while simultaneously invoking heavyweight formal exemptions to shield the background deliberations of what those exact exchanges say from public view. In the packet, you can see, pointing to the, I'm not sure if you were able to see the redacted grammar request, but when the trust attempted to examine the underlying administrative record, we were met with a wall of redactions. The county heavily redacted, withheld, and cloaked internal staff communications. In doing so, they cited attorney-client privilege and the deliberative process and pre-decisional draft protections. As a matter of administrative law, the county cannot have it both ways. If no formal reviewable policy was reached by the land use authority, there's absolutely no legal basis to claim deliberative process or pre-decisional privilege. You cannot have a pre-decisional privilege if there is no decision. The assertion of these high-level statutory protections is binding admission by the county that a deliberate, finalized, and structured administrative determination was reached. They treated it as a final administrative act internally to hide the record, and they must accept it as its status as an appealable administrative act externally. Under Utah Code Section 1779-1006, the appeal authority is bound by law to respect and uphold the due process rights of an appeal participant, forcing the trust to guess at the underlying administrative record due to widespread privilege claims, while simultaneously telling the trust that no reviewable decision exists to be appealed is a textbook violation of administrative due process. Turning now to the standard of review. Because the land use ordinance failed to specify an alternative framework for the evaluation of enforcement appeals, Utah Code Section 1779-10072 strips away all the administrative ambiguity. The statute explicitly commands that you must review all factual matters de novo, meaning you owe absolutely no legal deference to the principal code enforcement officer's conclusions or summary assertions. You should be looking at the evidence with entirely fresh eyes. Furthermore, Utah Code Section 1779-10074 lays down a strict rule of construction for your analysis. You must determine the correctness of the land use authority's interpretation based on the plain meaning of the land use regulations. The error we are asking you to correct today is a fundamental, systematic misconstruction of what a zoning development actually is under the laws of the state of Utah. The planning division and developer are treating the 2015 ZDA as if it were a private commercial contract. They're arguing that because the trust's legacy parcel sits just outside the active resort zone, even though we're fully encircled by this resort zone, the trust lacks contract privity and therefore has no business. The county has no business interfering. This is an error. Under Utah land use law, an executed and recorded development agreement is not a private contract. It is a public land use regulation that controls the use and development of a specific area of land. Let us look directly at the core physical violation. The developer has engaged in an illegal attempt to privatize a master plan mountain resort infrastructure. Specifically, they have taken an interconnected ski lift network, amenities designed, approved, and legally required to be integrated with the surrounding land, and unilaterally placed them behind a private paywalled membership model that requires ownership in their neighborhood. Legacy property owners who purchase land relying on the public covenants of this resort are now told they cannot access these essential recreational links. Not only that, we don't even have the opportunity to pay the private club fees to ski these areas. When the code enforcement walked away and characterized this as a civil matter between private parties, they committed a clear error of law. They failed to apply the plain language of the land use regulations. They failed to recognize that a recorded ZDA is a public regulation running with the land, and they committed a clear error of law by refusing to enforce it. And I'm just getting a little bit more into the details. Our HOA is not part of the ZDA. It does host a public trail. There was a condition of approval in the ZDA. I've got kind of a post-it note on there for you to pull that up if you weren't able to review it. This is private infrastructure that we It's our only access road. We own and maintain it.
Did review that.
Okay. Therefore, we're bearing the full impacts of the master, we're bearing impacts from the master plan without any corresponding public benefit. You can also see this in the recreation plan, and then the plat map that shows, our single point of ingress egress to our neighborhood, as a private road. Our neighborhood, which has been deintegrated from the resort, is worth approximately $1 million less than other lots that have access to recreational resort amenities that were committed as part of the ZDA as being public and are now private. All that's to say, there's a material deviation occurring. Also, uniquely, Powder Mountain West shares a water and sewer district with the developer's property. Due to the tax increment financing provided by the county, we now bear exorbitantly high rates, partially because the water district waived fees in their tax increment financing enabled by the county to help create the intended public benefits that we don't enjoy. It's also worth pointing out that the school district that basically forgave revenue as part of this tax increment financing is also furthering this private club. Nearly $6 million has been routed back to the developer, based on my public records request, and that was meant for our water district and Weaver County schools. And that amount will just keep increasing going forward. Under Utah Code Section 1779-1005, we recognize that the burden of proof rests on the trust as an adversely affected party to demonstrate that the administrative determination was illegal or clearly erroneous. And I think we've decisively cleared that statutory bar. Statutorily, we have proven an administrative refusal to enforce a recorded development agreement in writing explicitly satisfies the legal definition of an appealable land use decision under Section 1779-102. Factually, we've demonstrated that the county confirmed the finality and administrative weight of this decision by invoking formal executive and deliberate privileges under grandma. Legally, we've established that under the plain meaning mandate of Section 1779-1007, a recorded ZDA cannot be contractually compartmentalized to isolate, exclude, and strip away legacy resort integration promises. Then the planning division cannot look the other way while a master plan retains highly lucrative density entitlements while simultaneously discarding the public integration and access conditions that made those entitlements legal in the first place. Therefore, we are asking you to reverse the code enforcement determination and remand this matter to the planning division with an explicit administrative mandate to enforce the integration and access provisions of the 2015 ZDA.
I have at least one question, and maybe I'll wait until I hear from the county, if you have any response. So I guess I'll just time over to county. Yeah.
Could I have 2 minutes to consult with?
Of course.
The clients, please?
I guess we'll just recess for 2 minutes.
What you feel about that budget? It seemed not too bad. In the call yesterday, I'm trying to fill in.
Yeah. We're, I think we're getting a full review on it. Yeah, a little bit, but we're well within the range as possible.
Oh, good. That's great. Yeah, I think staying on that early and often was good because the more that we develop the drawings, the more detail they're gonna have, and the more it always ends up being, I think, pop up that they don't can't anticipate. So I mean, it's just really good to be having those right discussions now.
Yeah.
And just see how it flows. Yeah. I think they're a good group. I mean, you know, you get to a point where there's 50 firms that could build it. they're good.
Yeah.
Good quality group. Not hired, but they're working with them, negotiating stuff.
We keep it in 2 minutes.
It's over. Gone. Analyze them.
Okay.
All right. So back on the record, I need a gavel. But they probably give me one that squeaks, but. All right, so Mr. Erickson, do you have, I guess, any response or anything you'd like to add?
Do you want me to start or?
I'm gonna turn the time over to Cortland, but,
Okay.
in looking at state code and the definitions in them, we've talked about this with our legal team extensively over the last several months. A code enforcement officer is not a land use authority. We won't be reading the definition, and therefore a land use decision was not made in this case, and that's why we weren't sure if this was the appropriate avenue for an appeal of this kind or for a dispute of this kind. So I'll turn it over to Portland.
So, yes, I mean, as outlined in the staff report here, there are a lot of definitions in CLUDMA, and it is interesting the way they use some of those terms. The land use decision does mean an administrative decision of a land use authority or appeal authority regarding certain things. Land use permit, a land use application, or the enforcement of a land use regulation, land use permit, or development agreement. And so we have to look at each part of that and to determine whether or not, again, that even meets the criteria of a land use decision that can be appealed through this process. We do believe that although administrative decision is not defined here in this particular definition section, it would not fit within this scenario because it was an email exchange talking about the county's view of the situation. There was no formal application for which a decision was issued or anything like that. And the land use authority, which is defined as somebody designated by the local legislative body to act upon a land use application, does not include the code enforcement officer. She was not designated by the local legislative body to act upon any land use application that would be relevant to this situation. And so, based on the language of the statute, again, this is 1779-102. That's where the definitions he found. We would assert that there was no land use decision. In addition to that, I have a copy of a case. I'm going to hand a copy to the appealing party here and the hearing officer. This is Fuja versus Woodland Hills. The court there explained that there was a situation where a property owner's attorney sent some requests for action based on code violations to the city, and the city attorney responded, providing the city building officials' response to the code violations. The attorney for the property owners ended up filing ultimately an appeal related to the decision and determination made by the city to not enforce the city's zoning ordinance. That's from paragraph 6. The court analyzed the appeal, and in paragraphs 14 through 16, found that the appeals section under the Land Use and Development Act did not apply to that case because it said inaction on the part of the county was not considered a land use decision addressed by the appeals section in a previous case that had been heard by the state Supreme Court. So inaction was not considered a land use decision addressed by the appeals section. They did point out that there was another section of law that would allow an adversely affected party to commence proceedings to prevent, enjoin, abate, or remove an unlawful building, use, or act. But that was a separate code section requiring a separate type of legal action. And so we believe this situation is comparable, where there was not, again, a land use decision. It was inaction by the county. It was a statement by the county in a rather informal manner, saying that the county was not going to step in and take any action to try to enforce a development agreement. We will admit that there is language in the statute that does talk about, as has been mentioned, appeals of land use decisions applying to decisions related to the enforcement of the land use regulation, land use permit, or development agreement. But we think the court case explains that there is actually a distinction, and that this venue is not the appropriate way or venue for challenging that communication that was made by the code enforcement officer here. If you want to go on with the rest of the arguments, or just kind of line that's been stated.
That's in this song before.
Thank you. Blake, one more time, your last name.
Hoffmeister.
Hoffmeister, sorry. I am terrible with names, so, but at least I got your first name.
Yeah.
Because you are the applicant or the appellant here, you do have, as you mentioned, the burden, which means basically you get the benefit of having the last word as well, in this hearing. Obviously not the last word ever, but just in the hearing, you get to, in our regard, last word ever for this hearing, right? So, with that, do you have anything you'd like to add or rebut?
Yeah, so I'm familiar with this case. Basically, there's basically no action that was taken versus in this situation, there was a written determination that was provided to me. I think there's another case, Olson versus Park City, that gets into that as well.
Do you have a case citation for that?
I don't. But basically, I got a written determination, and if you just read the plain language of LUDMA, that's, very plainly what a land use decision includes, the determination that I requested.
So, can you address a bit about the land use authority, about, the county's claim is that the code enforcement officer is not a land use authority. Can we address that?
Yeah, I mean, the code enforcement officer consulted with, you can look at the correspondence. I think probably over 8 folks within the county. I think it's hard to say that, what was their terminology exactly, that the code enforcement officer is not a land use authority. It was presented to me as them being a land use authority, given that they wrote the decision and provided the formal administrative interpretation.
Do you have anything else you'd like to add?
Under 1727A 704, the board's jurisdiction is not restricted to decisions being made by a land use authority. The statute explicitly grants you the power to hear appeals from any administrative decision applying or interpreting a land use ordinance, of which a development agreement is.
All right. Anything else? Like I said, you do have the burden here, so you do get the last word. So if they have anything to add, then I'd still give you another opportunity.
I'm happy to hand out the list of definitions from that land use section from state code, unless you've already got it. Okay.
makes you feel better, I will receive a copy.
No, we're
Okay.
fine.
Would it be fair to respond the county code sets forth land use authority specific? Says who the land use authorities are enforcement. I'm Charlie. Keyword, yeah, sorry for the record.
For the record.
Thank you.
And what section of code is that?
There are a variety of sections of code, but if you're looking at, Title 102, applying, in certain circumstances, the planning director is the land use authority. That's regarding, it's in regards to permits. When it comes to subdivisions, for example, which I know this is not part of that, land use authority is split between the planning director and the planning commission. Conditional use permits are decided on by the planning commission with a few exceptions by the planning director. Beyond that, I'm not aware of any other statute that governs who land use authority is when decisions aren't.
Anything else from the county, and then we'll turn the time back over to Mr. Hoffman.
Yeah, I mean, I'd like to just note that we're not even taking the time to dig into the very important issues that I brought up and the enforcement of a recorded zoning development agreement that's binding on somebody's property. And instead, we're choosing to take the path of an administrative smokescreen. So I'd like to just point that out. A land use authority, basically, if you just read the plain language of what a land use decision is, this would be with it, it specifically states that it involves, the enforcement of a zoning development agreement. So
I guess just reading that definition straight from state code, it's under subsection 45, it says land use decision means an administrative decision of a land use authority or appeal authority regarding land use permit, land use application, or enforcement of land use regulation, land use permit or development agreement. So I do agree with you that enforcement of a development agreement can be a land use decision, but it still requires the land use authority to make that determination. So can you, your position is that the code enforcement officer is a land use authority. Is that correct?
I mean, yeah,
Or I guess an appeal authority.
yeah, that's the way that it was presented to me,
Okay,
right? So,
okay. And,
yeah,
is that
they
based on your
applied.
interpretation?
Yeah,
or
well,
did
they applied specific land use regulations to my property. Therefore,
And what specific regulations did
the
the land use authority apply to your property?
that the zoning development agreement does not apply, that they explicitly excluded our area. That it's a private, it's a civil private dispute.
The land use authority is the code enforcement officer. She had nothing to do with the application of where the development agreement, that was decided prior to that. Am I misunderstanding that? Because the development agreement was adopted in like
2015.
Okay. Okay, so, but it was never recorded against your property, is that?
That's correct. But
Okay,
we're an
I'm just trying to make sure I've got all the facts.
Yeah, but we're an adversely affected party
I understand.
for the first life.
Okay. But you're saying based on the emails, your interpretation is that they were a land use authority or at least acting in that capacity.
Yeah.
Okay, I just want to make
Yeah.
sure that I get everyone's positions here correct. And understand. So, sorry I interrupted you. Did you have anything else you'd like to add?
Yeah, I mean, I would say that what I received was an administrative decision. So it also doesn't say that an administrative decision has to be from a land use authority, but based on the applying the regulations and ordinances and the zoning development agreement in effect to my property, qualifies as a land use decision under just the plain language reading of the code.
anything else you wanted to add?
Yeah, I mean, I'd be happy to go through the actual issues if the county's willing to get into those.
So, and because we're here on the appeal of a decision of the land use authority, right, of the code enforcement determination. Right, so the enforcement of the development agreement is something that I can't get into today because we would basically essentially be denying due process to the, I guess, everyone that's subject to the development agreement, specifically that it's recorded against their property, not necessarily the territory. So, so that's something that I don't have the authority to get into today.
Okay. Yeah, just to restate, I'm not an attorney and,
No,
you know, I'd have to go back and review those definitions, but the way that it was presented to me and just the plain language reading of the code, that is my interpretation, that they were acting as a designated land use authority. And if they were unable to interpret those regulations related to my property, then they shouldn't have issued the determination. And, you know, that goes back to the Fuji case, and which, like, we actually did receive a formal written determination.
Okay.
Is our view of it.
All right. Thank you. So I was provided materials that weren't, I guess, able to be uploaded, so I am going to review those. I did review the entire packet that was provided prior to, so I'm not gonna make a decision here today. I will issue a written decision. I'm hoping to have something out within the next 7 days. Does that work for all parties? Any objection?
And does that trigger the 30-day appeal period, or I guess that the actual written determination from you is what triggers the appeal period? Is that correct?
I'm not able to advise you,
Okay.
so,
Okay.
but my decision, I do anticipate at least sending it out. I don't know that I have your email. I'd like to send it to all parties. So let me get your. What is your email? Actually, I think I do have it. It's in the materials, but just so I have it.
Blake.Hoffmeister. It's just first name dot last name
Okay.
at gmail.com, and it's HOFMEISTER@gmail.com.
Okay. All right, does that timeline work for the parties? And if it's turning out to be later, I will just send out an email informing the parties, but I do anticipate having something else in the next 7 days. Okay. All right. So that does conclude the first item on the agenda. And then I guess now we will go to the second item on the agenda, the variance request. So it's, sorry, I should have announced the agenda items. So 1.2 BOA 2026-02. And I've offended Mr. Erickson.
We don't need me here for this.
Thank you.
And you're welcome to stay. It is an open meeting, so.
Yeah, maybe you guys should have gone first. I think you're simpler.
Thank you for coming.
Yeah, thank you guys.
Good to meet you.
Yeah. I guess I probably should have had everyone state their name on the record when we started. Rick, you can yell at me for that.
All good.
Maybe Marty will get after me, but, everyone that is remaining, if you wouldn't mind just stating your name for the record and who you're with.
Ryan Rich with Altamar Group.
Tammy, Aydelotte, Powder Mountain County.
Matt Dersh, Gardner Engineering.
Mark Hillis, Mountain West Architects.
Charlie Ewert, Planning Division.
Rick Grove was fine.
And Matt Wilson, hearing officer. We did have Blake Hoffmeister, who was the applicant on item 1.1, and then Mr. Cortland Erickson, who's attorney for Weaver County, were also present. And no longer are they, but it's not permanently public limits. Okay, All right, as stated, you guys, because you are the applicant, you have the burden here. And then we'll give opportunity for the county to respond, and then you have the last word. So whoever wants to start.
I will start. Thanks for having me. I'm Brian Rich, with Altamar Group, partner and principal and authorized representative of the company. We are a local, small development firm. Two of our partners live locally in Eden and Liberty near the subject property. The property that we are discussing today is in Powder Mountain Village, Lot 3. And we are requesting a specific variance for the external outdoor decks and external staircase with projections up to 8 feet into the required 20-foot side yard setbacks from the Lot 3 podium. It is important to note that the underlying residential building that will be built complies with the CBR1 setbacks fully. It is only the open air unenclosed decks and one exterior set case that projects into the setback. So there is no living space that is part of this. The application for a variance is grounded in a physical and pre-existing hardship. This is not related to any economic or self-imposed hardships. And we have shown and provided the materials that the physical hardship and the other components meet the criteria for a variance. As a real quick background, there is an existing concrete podium on the property and a parking structure that was designed in 2006 and approved in 2007 with a conditional use permit. The residential building was never actually completed, and the structure has been dormant for over 15 years and has been obviously a challenge for the county in the area. There were also substantial deck footings poured and laid already on all 4 sides of the existing podium. So the original design that was approved by the county in 2007 actually contemplated and had the deck projections on every space of the structure already. We are simply proposing that we complete the deck structures as originally designed. We are adding no new decks, no new elements, creative or personal or for economic gain beyond what the ones that were already included in the original plans. There's a structural condition assessment that was done by an engineering group that confirms that the podium remains structurally sound. There are a few upgrades we need to make, but it's important to note that the supporting exterior walls of that concrete podium structure sit directly beneath the external walls of the residential structure that will be built. It is a structural requirement. It is not a design one. As a result, we are not able to pull the walls inward to be within the setback region area, which is not possible given the podium that exists and how the load-bearing walls work. There's also a few other physical constraints. The geometry of the property is very unique. It creates less buildable area given the required setbacks. And so more of that space had to be used by the existing podium itself. There are recorded easements that make it not possible for us to do some of the ground level outdoor that we could use as an alternative. And due to the slope and the topography, not possible to do there as well, which leads us to only utilize some of the external decks that we are requesting as a result. I'll pause there and Mark or Brad have anything to add?
No, I think that it was noted in here that the slope of the side is 18 feet. It's actually 25 feet.
25.
Yeah, across a half-acre lot. So it's pretty major, embankment and slope on that. So
Great, good call, Mark. I'll pause there.
So I was just kind of going through real quick to see how many variance requests we've had in this neighborhood, and we've had probably about 10 since 2017. We've got a lot of interesting features that go on with many of these lots. Some of them are unique shaped lots. We've got slope issues. We have ski easements that run through several of these. And these are typical narratives, frankly, for a variance request in this area. One thing we did do some research on, when we look at any of these requests for variance, we look for any way that the land use ordinance may allow the applicant to develop a property in the way that they're hoping to do. We do have some exceptions outlined in our code. We have a projections section in our ordinance that allows for certain architectural features to project into certain setbacks. In this particular case, the way our ordinance reads is that if it's not explicitly stated, it's not permitted. When we look at the projections section, there is no allowed side setback projection for uncovered balconies. So we will read that as there is no permitted projection for those at all within any of the side setbacks. And that is the reason for the applicant's request that's in the staff report.
It's that section.
It is 108-2, specifically A4. I'll go ahead and read a portion of it. It states unwalled porches, including roof-covered patios, terraces, balconies, may project 5 feet into a required front yard setback. Where the required rear yard setback is 30 feet or greater, a projection of 10 feet into the rear setback is allowed. Where the required rear yard setback is less than 30 feet, and in the CDR1 zone, the rear setback is 20 feet. A 5-foot projection into the rear yard setback is allowed. There's nothing that allows for a side setback projection for these features. I'm not sure if you were present when the request was made by the previous Board of Adjustment, that planning staff do not make recommendations to them regarding these requests. We simply state the ordinance that we've applied, the 5 criteria, and then we allow the applicant's narrative as it is their burden of proof to show that they meet those criteria. So you won't find a recommendation in the staff report.
That's right.
Okay.
If you would like that changed, this is Rick Roller for the record. If you'd like that changed in the future, just let us know.
Okay.
Anything else from? Okay.
Yeah, so just lastly, for me, a reminder, this is not related to a design preference that we had. This is a physical element with the existing property that has existed since 2006. It was permitted and approved at that time with those existing footings that were contemplating those decks at the same time. So this is simply a request to complete what was previously approved, and is we believe a physical and hardship that is very peculiar to the property. And as far as the other criteria related to the variance, mentioned again, that this is not self-imposed, it's not economic. We also believe that the other CBR1 parcels in the area provide outdoor living space, which is very much part of the enjoyment of these types of properties up there. And without the ability to have a projection outdoor space because of the hardships that we talked about would not be available at this property, and therefore would not provide the outdoor space that is substantially available to other CBR1 properties in the area.
You said the footings were poured. When were those poured?
Same time,
So back in
2006
20
or
years,
so.
20 years ago. Doesn't seem like it's 20 years ago. Okay, and at that time, this was all, had you gone through, or had this project been pushed through at that time, it would have all been within setbacks at the time, or would it have needed a variance then as well?
Mark, you know that?
We're unclear on that. We haven't seen one way or the other. We assumed that there was some sort of a mechanism that allowed it at the
Okay.
time.
Okay.
We just haven't seen it, seen what that is.
That's right. And then Tammy, you said 10 variance requests in that neighborhood in the last 8-9 years?
Yeah.
How many of those were granted?
all of them.
Okay. All right, so. Um. Alright. Get the wheels greased up there. So, I will tell you that in my experience, 90% of variances they are granted are generally not lawful. I'm not telling you one way or another. I'm happy to issue a written decision. I think I can issue a decision as well today. If you'd like, so however the parties would like to proceed, I guess I'll probably do a written decision regardless, but I can indicate, I think, which way I would likely be going.
We prefer a decision today.
Okay. So, based on that, I think I would, I am inclined to grant variance in this case. And some of the, I think, yeah, just looking at, obviously, the variance code, you need to meet each and every element of that code, so that's under 1779, 1002, subsection 2A. First one, the appeal authority may grant variance only if the liberal enforcement of the ordinance will cause an unreasonable hardship for the applicant that is not necessary to carry out the general purpose of the land use ordinances. And I think in looking at each and every one of the elements, I think you do meet that. Maybe it's a stretch on some of them, but I think it's there. Yeah, so I would grant variance, but I'll still issue a written decision. Probably a little longer than 7 days. Just because we have another one, but I'm hoping to route through it this weekend and get the decisions out. So, all right, great.
Yeah, no, Sam.
Maybe my contract will be terminated after that. Excellent. So,
That overall setting is that there is a lot of open space there,
Thank you.
hey, thank you.
Yes.
Now let's adjourn the meeting. Thank you.